Major breaking news out of the United States Court of Appeals for the Ninth Circuit in San Francisco, California. The Ninth Circuit has denied a request to rehear their quote-unquote sensitive places ban case en banc. Specifically, the lower court in a 3-judge panel decided mostly for the anti-gunners in a fight over sensitive places, not entirely. We'll break down this fight. This fight involves not only the state laws of California, but also the state laws of Hawaii. Let's break down what happened today in the Ninth Circuit, including a very powerful dissent by a potential future Supreme Court nominee, Judge VanDyke, the Honorable in the Ninth Circuit. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in the category of top voices of the Second Amendment for the 2025 Gundies Award to be awarded in Las Vegas next week. I'll let you know how it goes. I appreciate all your support. Great people out there fighting for our rights every day, and it's an honor to be associated with all of them. All right, folks, we have breaking news. Most people are going to call this bad news. It generally is bad news, but it's not entirely bad news for the Second Amendment, okay? Bottom line is this. As you may recall, after the 2022 decision in Bruen, a bunch of states passed a bunch of laws, as I predicted, and as you know, labeling everywhere in their state, quote-unquote, sensitive places, which sensitive places is a euphemism for government-mandated gun-free zones. 2 of the states that went nut on enacting gun-free zone laws just by labeling them as such was the state of California and the state of Hawaii. So even though Bruen required these states to shall issue permits to carry guns, they basically, both California and Hawaii, made it very difficult to actually carry your gun anywhere in public because they labeled everything a gun-free zone. Now, about 6 or 7 months ago, a 3-judge panel in the Ninth Circuit, in these 3 related cases, the 3 names of the cases are, this is the Reno May case, Marco Antonio Cararello, and the Wolford case. I believe these are the 3 cases, Wolford, Reno May, and Cararello. Hope I did not screw that name up, Cararello. Okay, I apologize if I mispronounced Marco's name. Nevertheless, these 3 cases got consolidated. They were argued in front of a 3-judge panel in the Ninth Circuit, and as I explained at the time, the 3-judge panel was a terrible panel for the Second Amendment. They were clearly anti-gunners. There was not a lot of hope to win, but a miracle occurred. Out of that 3-judge panel, there actually was a ruling that said that many places that California and Hawaii had labeled sensitive places were actually not allowed to be sensitive places under the Second Amendment. Also part of this decision, you may recall in these 3 kind of consolidated cases out of California and Hawaii, they also said the so-called vampire rule or the default rule that says you can't go into a public place like a gas station, a convenience store, a grocery store, whatever, without first getting permission of the owner to carry your gun, even though it's virtually impossible because if you're driving on a highway, you pull over to get gas and you walk into a convenience store, you don't even know who the owner is. Nevertheless, the Ninth Circuit panel here knocked out a lot of sensitive places. They upheld a lot of sensitive places, and then they specifically, and this is what was weird, they said that the California vampire rule or the default rule that said you had to ask Mother May I permission to carry your gun into a public place, that was unconstitutional as dictated or articulated by California, but somehow it was constitutional the way Hawaii did it. So I said California, the default rule was unconstitutional, but under Hawaii, it was fine. Somehow that made sense according to the Ninth Circuit panel. Nevertheless, my recommendation at the time on this channel, which I made public, was I thought that the plaintiffs in this case, given the panel and the composition of the Ninth Circuit, ought to just go back to the district court and lose fast, get a final judgment, because remember, these cases are Cararello, Reno May, and Wolford. I think that's the 3rd case that's related to this, okay? These 3 cases are on preliminary injunctions. They're trying to get preliminary injunctions to enjoin these laws, and I applaud the effort, but it's pretty clear that ain't going to work. So when you know your preliminary injunction ain't going to work, you ought to go down and make sure you lose fast, get a final judgment against you fast, so you can get to the United States Supreme Court fast, because as you know, unless you're dealing with an immunity issue, which none of these cases deal with immunity, so that exception doesn't apply, the United States Supreme Court is not going to grant cert, or it's highly unlikely they're going to grant cert and hear a case when the procedural posture is a preliminary injunction. So because these three cases on the procedural posture out there in California and Hawaii on a preliminary injunction basis, the odds of getting to the U.S. Supreme Court and granting cert in any of these cases is not very high, to say the least. And the odds of getting a rehearing en banc I thought was sketchy as well. Nevertheless, I actually thought you could go backwards because there was at least some victories from the Ninth Circuit three-judge panel that could have been overturned en banc. So with this background in mind, what happened? The U.S. Court of Appeals for the Ninth Circuit today denied the request to hear these cases en banc. In other words, the entire Ninth Circuit said, no, we're not going to hear these cases en banc. That means the panel decision of the three judges is going to continue on as is. No interruption, no change, no amendment to the three-judge panel that said some places can be sensitive and some places cannot be sensitive. And we'll go through the list in about 30 seconds here. But there was a very powerful dissent that argued that the panel decision was so far off the rails in terms of following the Supreme Court precedent and the text of the Second Amendment and the history of the Second Amendment that the Ninth Circuit should have heard the case, reheard the case en banc. And that was a powerful dissent by Judge VanDyke, who is definitely going to be on the list of individuals that Donald Trump, as President of the United States, will consider to put on the United States Supreme Court if a vacancy were to arise. So Judge VanDyke wrote a very powerful dissent explaining why the panel's decisions were off the rails and violated the Second Amendment and violated the history of the Second Amendment, violated the Supreme Court precedent. 6 ways to Sunday, but we'll get to that in 1 second. So just as a reminder, before we break down that dissent, I want to remind you what the Ninth Circuit panel said in terms of what are constitutionally, in their opinion, can be banned, where you can have a gun ban as a sensitive place and not violate the Second Amendment. Then I want to go through the list of places that under the Second Amendment you cannot make, quote-unquote, a government-mandated gun-free zone. So in terms of the quote-unquote sensitive places that the three-judge panel several months ago said was fine, these laws banning guns in the following places was perfectly acceptable under the Second Amendment, is the following list. They said that you can ban guns under the Second Amendment in bars, in restaurants that serve alcohol, even if you're not drinking, on beaches, on parks, on recreation areas, wilderness areas, playgrounds, youth centers, athletic centers and facilities, casinos, similar gambling establishments, stadiums and arenas, public libraries, zoos, museums, amusement parks, and parking lots associated with places where guns are validly banned, such as private property in Hawaii and so on. Okay? So the point is, as a general matter, those were the places that the Ninth Circuit said you are allowed to ban guns if you're the government. But the Ninth Circuit panel, even though it was a terrible panel, actually said there were certain places in California and Hawaii, and I'm blending the two states, by the way, for simplicity's sake here. You can read the opinion if you want to get more details and break it down more specifically. So I'm blending the states for simplicity for the purpose of this video. But here's the list of places that the Ninth Circuit panel many months ago said government cannot ban guns based on the text and history standard of the Second Amendment and NYSERPA versus Bruen. The places where you're not allowed to ban guns, according to the Ninth Circuit panel, was banks, financial institutions, and their parking lots shared with government buildings and non-governmental institutions, hospitals, and similar medical facilities, public transportation areas, and gatherings that require a permit, places of worship, and of course, we know that the California default rule was declared unconstitutional, but the Hawaii default rule that we previously mentioned in this video was declared constitutional. If you can square those circles, good luck, because I can't really do it in a very good way. Okay, so that's where we are. So the Ninth Circuit panel said some places were sensitive, and that's fine. Other places deemed sensitive were not fine. They went through the list, and then again, the lawyers for the Second Amendment plaintiffs sought en banc review, which means in the Ninth Circuit that a whole bunch of the judges, not every judge of the Ninth Circuit, but most of the judges, if you will, get called together, and they decide whether or not to rehear the argument among all the judges in the Ninth Circuit instead of just that 3-judge panel. And as a side note, because the Ninth Circuit has so many judges, because it's so big, it's actually not the entire Ninth Circuit, but it's kind of the bulk of them for your purposes. That's all you need to know. Now, so what happened today? Well, the Ninth Circuit said, nope, we're not going to disturb the Ninth Circuit panel. The 3-judge panel is perfectly fine. Their ruling is perfectly fine. We're going to uphold it. No change, no amendment, no nothing. Okay? But there was a dissent by 2 dissents, actually, totaling 8 judges. Did you hear what I just said? There were 8 judges on the Ninth Circuit signed off on dissents arguing that the Ninth Circuit panel of 3 judges several months ago basically got the Second Amendment methodology incorrect. They got it wrong. The most powerful dissent, which goes on for many, many pages, and you can read it down below, I'll put a link to it down below, is a powerful dissent, which is excellent, by Judge VanDyke, who undeniably is on the list to be a possible Supreme Court pick by President Donald Trump. 100% VanDyke will be considered by the President of the United States, along with some other very powerful judges out of the 8th Circuit and the 5th Circuit, and a few other places, which we will get into when we get through these confirmation hearings. When we pass the confirmation hearings, we'll start talking about this in another few weeks or a month or so. Okay. Now, with that said, Judge VanDyke's dissent was very powerful because he goes through in great detail and points out that the historical analog laws that are relied upon by the 3-judge panel, many of them were simply outliers. They were one-offs. Remember, the standard is that once the text of the Second Amendment is implicated, and undeniably it is when you're banning guns in a place, because your right to keep, which means to possess, and the right to bear, which means to carry guns, is implicated if I can't bring a gun into, like, the gas station, right? My right to carry the gun in public for self-defense is implicated and infringed upon if you say I can't bring the gun into the grocery store, or the gas station, or the bar, or the stadium, whatever it is. So then the burden shifts to the government, and the government has to show a long-standing historical tradition. Hear what I just said? A historical tradition, not pinprick, rifle shot, one-off outlier history. Hear what I just said? It's about a tradition, not an outlier, not a one-off. You can't just be like, oh, there's like one law in the Southern District of Illinois in 1879, and there you go. No, that's not a tradition. It's got to be a tradition, something well established, like Thanksgiving is a tradition, because we've done it every day for 100 plus years. That's a tradition. Christmas is a tradition. Same thing. These are traditions. Okay, some one-off event is not a tradition. And yet Judge VanDyke in his dissents points out that most of the laws that are relied upon by the anti-gunners and by the state of California and the state of Hawaii, but I repeat myself, of course, were outliers. Okay, and you can't rely on an outlier because outliers don't give rise to a historical tradition because they're outliers. They're one-offs. They're atypical. Beyond that, Judge VanDyke points out that a lot of the laws relied upon by Hawaii and California are not even really related to the notion of sensitive places. There are other kinds of firearms regulations, but not specific in terms of the why they were enacted and the how they were enforced, and therefore they're not really appropriate analogs, historical legal analogs. So therefore, there's just no tradition of regulating firearms or banning guns in these kinds of places as a matter of American history, going back to the time of our founding of 1791 when they enacted the Second Amendment, which is the relevant time period, because if you're going to try to understand what does the Second Amendment mean when it was enacted in 1791, what time period do you think you ought to look at? Hello? Obviously, the time period around 1791 to figure out why the Second Amendment was adopted, because they're the people, those were the Americans that adopted the Second Amendment and the rest of the Bill of Rights. So what were they thinking? What were they trying to accomplish? That's why you look at that time period and not, let's say, post-Civil War periods where all the founding fathers and people involved with the enacting of the Second Amendment are long since dead, right? And Judge VanDyke talks about this. He also talks about how the panel engaged in an error by engaging in deriving principles at too high of a level. Because if you think about the way this works is you look at historical examples of laws, and from that you derive principles. Now, just by looking at random laws, you can say, oh, well, the principle there is people enact laws to protect public safety. Well, that's an extremely high-level principle, but the Supreme Court says that's not enough. You got to be very precise, and this is consistent with other areas of the Supreme Court jurisprudence, including for you legal geeks out there, how they handle cases involving unenumerated rights under the substantive due process clause of the 14th Amendment when you're in that world. Okay, but we don't need to get into that geeky detail for the purposes of these videos, or this video today. But the point is, Judge VanDyke really makes mincemeat of the arguments and the reasons articulated by the Ninth Circuit panel as to why they declared something sensitive and why they said something cannot be sensitive. And I said at the time that I thought that the Ninth Circuit panel did not do a very good job. I thought it was mediocre reasoning at best. They are very sloppy and just tried to get through this. And clearly, we're not thinking hard in any respect. And it's the kind of thing that I would expect out of a very average college student, and certainly not any kind of a great college or great law student, never mind a powerful set of judges. I did not think the work product of the three-judge panel was particularly good, and Judge VanDyke did an excellent job in dozens and dozens of pages of explaining why he didn't think they did a good job either. And by the way, there were 7 other judges, in addition to Judge Lawrence VanDyke, that basically said we should rehear this case en banc as well, because the panel did not exactly do a great job. Hint, hint, wink, wink. Therefore, we need to rehear this case en banc. And just to give you a sense of the kind of powerful language used by Judge VanDyke in his dissent, here is what he writes to sum up, or basically to lead off, his dissenting opinion as to why, in his opinion, the Ninth Circuit panel should have been revisited, that decision should have been revisited by the entire Ninth Circuit en banc. This is what Judge VanDyke writes. Just a few years ago in Nysurper versus Bruen, the United States Supreme Court made clear that the Second Amendment includes the right to bear firearms in public. With its decision in these cases, our court, that's the Ninth Circuit, allows governments in our circuit to practically eliminate most of that right. Powerful language. With its decision in these cases, our court allows governments in our circuit to practically eliminate most of that right. In response to Bruen, both Hawaii and California declared a broad and unprecedented number of locations to be prohibited sensitive places, and on top of that imposed novel criminal sanctions for concealed carry onto private property absent express permission received well in advance. With this court's blessing, law-abiding and licensed citizens in the circuit can now be banned from carrying firearms in most public and private spaces. Apparently, notwithstanding Bruen's instruction that the Second Amendment protects a right to carry a firearm in public, what it really protects is the right to carry only while taking your dog out for a walk on a city sidewalk. If only New York City had been creative as California and Hawaii, it too could have avoided Bruen and succeeded in banning firearms throughout most of Manhattan. And I don't think that's right. Powerful language from Judge Lawrence VanDyke in that dissent, which goes on again for dozens of pages. I urge you to read it. It's very powerful language, and we can talk more about sensitive places in the future as to what happens next, because this is a preliminary injunction platform, or this is the sort of the basis of, or where this case is right now. You know, the lawyers may seek cert from the U.S. Supreme Court, but I would say that is a very, very, very long shot. There's any real shot that that could be granted cert. I think that's highly unlikely in this context. So if I were advising the parties in this case, which I'm not, but if I were, I would tell the Firearms Policy Coalition, the Gun Owners of America, the Second Amendment Foundation, the California Rifle and Pistol Association, and all these other gun groups, and I applaud them all, and all the other plaintiffs, and I applaud them as well, to, you know what, go on back down to the district court, get a final judgment, lose your case as fast as you can lose this case, and then go back up on appeal and see if you can get to the United States Supreme Court in the next, 18 months to 24 months. But at this point, I think you're probably going to be spinning your wheels. If you try to get cert now, you're just going to delay the inevitable. Better to go down and unfortunately get your final judgment, lose the case fast, and then take an appeal from the final judgment. But again, I'm not advising any of these people, so they can do whatever they want, and they may have reasons that are better than what I can come up with. But the reality is, I suspect the Supreme Court is simply not going to intervene in this case for the moment, because it's an interlocutory appeal, and we know they don't like interlocutory appeals at the United States Supreme Court, absent an immunity issue, which is a special kind of animal that doesn't apply in what's going on in these cases of Wolford, Carolero, and Reno, May. Okay, folks, hope you enjoyed today's episode, even though we had kind of a bad outcome. The reason why I did not think it was a catastrophic outcome is because at least some of the sensitive places that California and Hawaii labeled sensitive got knocked out by the panel, and that still continues, meaning they're not sensitive. So that's a positive at some level, but obviously we're going to need to do a lot better better than this moving forward. So there you have it. Make sure you follow me on X at 4Boxes Diner. Don't forget to follow me on Rumble and subscribe on YouTube, both. And I look forward to talking to all of you again very soon here at the 4Boxes Diner.
Orders up. Table 2A.